Hey there, so in this video, we're going to talk about the new Secure Act, Inherited IRAs, and Stretch IRAs. Okay, so let me give you some background. I'm Paul Rabley. I'm an estate planning attorney. I help our clients get and keep their legal affairs in order. And up until January 1st of 2020, when an IRA owner died and named non-spouse beneficiaries of their IRA, then those beneficiaries could take those required minimum distributions or those taxable distributions over the beneficiary's life expectancy. So let me give you let's give you an example. Let's say Dad had $1 million IRA. He died. He named his wife or mom as the designated beneficiary. The rule hasn't changed there. Mom could, move Dad's IRA into an IRA in her name. And then under the old rules, when Mom died and left the IRA to non-spouse beneficiaries, let's say the children, then the children, regardless of their age, could start taking distributions over the children's remaining life expectancy. Let's say a child, when that surviving spouse, that surviving mom died, let's say a child had under the IRS tables, they had a 40-year life expectancy. And let's just say, make it simple, let's say there's just one child involved. So after mom dies and there's $1 million IRA, well, the child need only take 1/40th of that IRA as a taxable distribution. If the IRA was $1 million, 1/40th of that, because the child had a 40-year life expectancy, would be 2.5% or $25,000. The remaining $975,000 would continue to grow tax deferred, perhaps until the next year when the child has a 39-year life expectancy and the child takes out 1/39th of that inherited IRA. And again, that scenario gave both parents and children a lot of peace of mind, knowing that it's going to be a long time before the children or the child or the grandchild, whatever it is, runs out of money. So now we have this brand new tax law called the Secure Act. It stands for Setting Every Community Up for Retirement Enhancement Act of 2019, again known as the Secure Act. And what the new rules do a number of things regarding retirement plans, but I'm focusing really exclusively in this video on the inherited IRA. So the new rules require a full payout from the IRA within 10 years after the death of the IRA owner. So to me, that has two pretty significant consequences that I don't see discussed much in the initial round of discussion that I see about the Secure Act. But one of the consequences of the Secure Act, at least insofar as consequences of this required 10-year payout, is in general, when an IRA owner dies and leaves that IRA to non-spouse beneficiaries, typically the children, because the normal IRA beneficiary designation, right, wrong, or indifferent over the years has been just like my previous example. Dad names mom as the primary beneficiary and dad names children as the contingent beneficiaries. Dad dies, it goes to mom. Mom names children as primary beneficiaries. And so the general trend, just based on life expectancy and how long people work and how long people live, is, most children inherit that IRA typically when they're perhaps 50, maybe in their 50s, maybe in their 40s, maybe in their 60s, because the parents pass away when they're in their 70s, 80s, some into the early 90s. So what that means is, under the old rules, when a 50-year-old inherited an IRA, they could think to themselves, in fact, I will tell you, my father had an IRA, passed away about 4 years ago, named my mother as the beneficiary, so it went into an IRA in her name. My mother passed away about 6 months ago, and so that she named the 5 children, one of whom is me, as the beneficiaries. So my mom's IRA was split up into 5 ways, and my mom's IRA now sits in 5 different inherited IRA accounts. And I was thinking when I got it, I'll just take those required distributions every year. I'm 54, and it's not a whole lot of money, but I felt like I'll just keep deferring that tax. But now for when an IRA owner dies in 2020 and beyond, it's a different set of rules. So they must take that required distribute those distributions over 10 years. So the general trend is when people inherit IRAs, and I've been seeing people come through the office over the last several decades, one after another. They inherited IRA, dad died, mom died, IRA was left to kids. And those kids, they generally are in their 50s, maybe their 60s, maybe their 40s. And so now they're having to pay tax on all of that IRA amount that they've inherited during the next 10 years. And so when a 50-year-old inherits an IRA, now moving forward, that 50-year-old has to take the money out of the IRA and pay tax on it at the latest when they're 60. So now beneficiaries of non-spouse beneficiaries of IRAs, who are typically the children, are going to have to pay tax on that amount during their highest income earning years, from when they're 50 to 60, if they were 50 when they inherited the IRA, or from 55 to 65, or 45 to 55, or 60 to 70. And again, part of this new Secure Act is some type of acknowledgement by the IRS or Congress that people are working longer because they postpone the required minimum distribution age for an IRA owner from 70 and a half to 72. So it's going to require that inherited IRA owners pay that tax within 10 years. And in many cases, they're going to have to pay that tax while they have they're in their highest income earning years from their employment that they're involved in. So that's one consequence of this new Secure Act. The other consequence of this Secure Act is, boy, I know a cajillion, and that's not a real number, of estate planning lawyers who for years have been sitting across the table from their clients, and their clients tell us attorneys something like this, not necessarily in these words. I'm going to be kind of blunt, but us attorneys hear from our clients something like, okay, Mr. or Miss Attorney, I have $1 million IRA, and yes, that will go to my kids when I die. And here's the blunt part. They dance around something like, you know what, Paul, my kids aren't smart enough, financially mature enough, responsible enough, have a spouse who influences them too much enough. So what I want to do with my IRA to make sure my kids get income and get the tax deferral is I want to leave my IRA when I die to a trust for my child or for my children, and I want to require in that trust that my children get only the required minimum distribution from that IRA, for the rest of their lives. Sometimes we call that a stretch IRA. Sometimes we call that a see-through trust. And so what the parent has been trying to do is keep the child from screwing up by taking a total distribution, paying all the income tax, and then spending all of the money. And then poof, the entire IRA that the parent intended to left the child is gone. So now when parents leave that IRA to a trust, which says the trustee must give the beneficiary of the trust the required distribution only, there's going to be only 1 year where there's a required distribution, and that's going to be 10 years after the parent dies. And that's when the child's going to get all of it at once, and it's probably going to cause them to pay a lot more tax than if those taxable distributions had been spread out over 10 years. So This thing is really going to throw a wrench into a lot of people's plans. So now, look, if you have an IRA and you did what I would think most people have done, kind of the traditional, I name my spouse as my primary beneficiary and I name my children as my contingent or secondary beneficiaries, then I don't know that you necessarily need to do anything different. If that was what your intent was under the old rules, then you may not need to change anything. However, if you said, when I die, I leave, you worked with an estate attorney and you went through all these scenarios and you thought these rules that would allow distributions to take place over your children's lifetime, you thought those rules would never go away. So you designated a trust as the beneficiary of your IRA and you had some peace of mind that your children would get income for the rest of their lives, or at least for the rest of their life expectancy, then all that's been just kind of thrown out the window, and you probably need to revisit what you've done, which means go back to, look at your beneficiary designations. If there's a trust, then, you probably need to revisit that with your estate planning attorney and, make sure that what you're trying to accomplish gets accomplished under the new rules. So that's the second consequence. Again, the first one was people are going to be inheriting, non-spouses, children, grandchildren are going to be inheriting IRAs in their maximum income earning years, and when they've got to take all of that inherited IRA out over a 10-year period, that's going to be a large sum of tax, because that distribution or that taxable income will be on top of the other income that they have through their jobs, through their businesses. So that's kind of a bummer. And then the second one, if you named a trust as a beneficiary of your IRA to try to restrict perhaps a child or a grandchild from being able to take it all out themselves, pay the tax, and then blow the money, better revisit that, because when in that trust you stated that the trustee must distribute to the beneficiary that required distribution, well, that has a new set of rules and new meanings now, so that's going to cause you to revisit it. Okay, so those were two consequences. And then maybe another thing that I think is real important is just stay tuned. Subscribe to this YouTube channel and click the notification bell so you don't miss anything as I keep educating the public on what this new law means. It has significant consequences to many, many people out there in America. And then, there's a share arrow on your screen somewhere where I'm going to ask you to share this with your friends, your children, your colleagues that may also have most of their savings in an IRA and want to make sure they do the right thing to protect it for themselves, their spouses if they're married, their children, their grandchildren. So it's kind of a big deal, and I kind of look forward to helping you sort through it through these videos, and of course we'll be helping people through our office as well. I'm a Louisiana attorney. I help our Louisiana clients get and keep things in order. So I look forward to digging into that Secure Act a little deeper and keeping you posted. All right, we'll see you next time.